Hello, my name is Viktor Kalgin and I work at KPMG Russia and specialize in corporate taxation. I help my clients who are multinational companies, Russian companies, wealthy individuals and their family offices to resolve complex tax issues and find solutions, especially in situations where more than one country is involved and there are international structures or cross-border situations. So this is my area of expertise. Last year, there were two important tax developments that probably affected everyone who works with cross-border structures where Russia is involved. And with our colleagues, we decided to prepare a practical webinar and practical materials to help our clients to understand how they can use these developments to mitigate their tax risks and improve their structures where Russia is involved. So this video is part of the preparation process, and I'm going to talk about these new developments, this good news, and how they can be used in particular situations. So two important tax events at the end of last year are the new law, the law dated the 27th of November, that changed several rules, or quite a number of rules concerning different situations and especially cross-border structures. And of most importance probably are changes related to withholding taxation and the beneficial ownership concept. And we're going to talk about this in a few minutes. The second change is a court ruling which was issued at the very end of last year. And this is the first positive court ruling, positive for the taxpayer, where beneficial ownership concept was applied. And the conclusion of the court was that a Dutch holding company was eligible to treaty benefits and was the beneficial owner of dividends that were paid by a Russian company. And therefore, this company could have applied the reduced 5% under the Russia-Netherlands tax treaty. And this, although this is the first instance, and the story will probably continue in the next instance courts, but this is an important development because we hadn't seen positive court rulings on beneficial ownership concept for more than a year. And in particular, in relation to dividends, there hadn't been positive court rulings since probably 2016. So these two changes, these two developments, they affect cross-border structures where there are payments from Russia to foreign companies that are subject to withholding taxation. And these changes, they create more certainty and more new tax risk management opportunities, especially in relation to the so-called look-through approach, and in situations where holding companies are used, and some arguments from the court decision can be used to defend the beneficial ownership position of holding companies. So in this video, we are going to talk in a bit more detail about the look-through approach. And before we do this, I would also like to mention the survey that we decided to conduct among our clients and contacts to understand what issues, what practical difficulties arise in relation to withholding taxation in Russia, in order to understand what solutions or what improvements can be made using the most recent changes. And more than 70 people participated in the survey, to which I'm really grateful to the participants for sharing their questions, practical situations, and issues they face in relation to withholding taxation. And we see that although practical difficulties and situations vary, there are at least three main areas that cause questions, and there are three main areas of concern when it comes to withholding taxation in Russia. The first area is the beneficial ownership criteria, conditions. And indeed, this concept, although this concept has been applied for several years already, still uncertainty remains, and it is often difficult to say which particular entity in the structure is the beneficial owner of a particular type of income. And it is often difficult to say with enough certainty whether a particular, let's say, foreign company, non-Russian entity, can apply treaty benefits. Because if the Russian tax authorities disagree that this company is the beneficial owner of income, then they would deny tax treaty benefits and challenge the reduced withholding tax rate. So beneficial ownership criteria, this is the first area of concern. The second one is the beneficial ownership confirmation. And indeed, this is a document which has become obligatory, but still there is little guidance in relation to the contents of these documents. And this is a formal document which should be provided to the Russian company in order to enable it to apply tax treaty benefits. And if this document is not in place, if the foreign entity that receives income doesn't provide this document, then formally there is no grounds. There are, it is not possible to apply reduced withholding tax rates and tax treaty benefits. So this is a mysterious document because there is little guidance about it, and the tax code doesn't say much about the contents of this document. So this is the second area of concern of our clients. And the third area is the look-through approach. And we are going to talk about the look-through approach in a bit more detail in this video. So let's consider a structure where there is a Russian company that pays income, let's say, to a holding company. It can be dividends, interest on any other type of income which is subject to taxation and source in Russia. And from legal perspective, this income can go up the chain up to the ultimate parent company, which creates questions as to whether the immediate recipients of this income can qualify as the beneficial owner and can claim treaty benefits. This is why, for tax purposes, it is possible to apply the so-called look-through approach and look directly at the ultimate recipients of income, let's say ultimate parent company, and apply tax treaty benefits to this company. Okay. So what problems did the new law solve in relation to the look-through approach? There are at least four areas, four issues that this law addressed. So first of all, there was a question whether the look-through approach can be used to income other than dividends. Although there were clarifications from the Ministry of Finance that confirmed that income other than dividends can be subject to the look-through approach, the uncertainty remained until the law changed it. And now it is clear from the new provisions of the tax code that the look-through approach can be used not only for dividends, but for other income subject to withholding taxation, such as interest, royalties, international shipping, etc., etc. So any income subject to withholding tax can be for every type of income, the look-through approach can be used. So the second area where there were improvements is that now it is not required to apply the look-through approach to use this approach in proportion to the share of the beneficial owner of income in the company, in the Russian company that pays dividends. There was a wording in the law that suggested that only in proportion to that indirect share, the look-through approach can apply. But unfortunately, in many cases, there are disproportionate distribution of dividends through the chain, or there could be different classes of shares or different preference shares, for example, can be used so that the distribution of dividends up the chain may not be proportionate to the share in capital that the shares represent. So this issue was solved, and there is no requirement in the law to hold indirectly the proportionate share of capital in the company, in the Russian company that pays income, in order to apply the look-through approach. Okay. So the third change is that it is not necessary anymore to apply the look-through approach. It is now not necessary that the immediate recipients of income should be in the country with which Russia concluded the tax treaty. The look-through approach the rules before the changes were drafted in a way that suggested that only a company in a tax treaty country should be present in the structure in order to enable the application of the look-through approach. So the good news that this is now that this wording is excluded from the law. It is not necessary, and in structures where the immediate recipients of income paid from Russia is an offshore entity, in these structures it is still possible. It is now possible to apply the look-through approach. Although there were positive clarifications from the Ministry of Finance in relation to structures where the immediate recipients of income was an offshore entity, there were positive clarifications, but unfortunately, uncertainty remains due to the wording of the law. It is now changed. And the fourth, the last but not least, important change is that it is now easier to apply the look-through approach for certain categories of income recipients. So there are 4 categories of entities that can apply the look-through approach based on simplified rules. Those are individuals, state-owned companies, sovereign funds, and public companies. So for these 4 categories of entities, it is now easier to apply the look-through approach, and basically it is only necessary for this entity if it qualifies as if it falls under this category. It is now sufficient for this entity to claim its beneficial ownership rights. So the law says that as long as the entity claims its beneficial ownership right, it fulfills the conditions to apply the reduced or apply the look-through approach, the reduced tax rates with treaty benefits, as if it is the beneficial owner of income. Because previously, uncertainty remained as to whether the tax authorities would agree that the entity that is presented as the beneficial owner of income will indeed be considered by the tax authorities as the beneficial owner, and there could be different views because the concept is vague and unclear as to whether a particular treatment will be accepted by the Russian tax authorities. Now, at least for 4 categories of entities, the look-through approaches can be applied in a simplified manner. Okay, so that's it for this video. In the next videos and other materials, we are going to look in more detail at the look-through approach in relation to dividends. We will talk about the confirmation of beneficial ownership, which was one of the areas of questions that we received during the survey. And we'll talk about the arguments that can be used to defend the reduced withholding tax rates, especially in the context of the new arbitration case law developments. So thank you for your attention, and please leave your comments to this video. I will be grateful if you could share your ideas, questions, issues, practical situations, and let's be in touch and see you in the next video. Thank you.